So good afternoon, everybody, and thank you for joining this very special webinar this afternoon. And a special thank you to Lisa Krueger Khan, who is with us today. Lisa is a specialist in immigration law and has helped many entrepreneurs fulfill their dreams of living in and working in the US via the E2 visa route. Regal Maids service was built by entrepreneurs, including myself, and it's something that's very close to my heart. Lisa has been practicing immigration law since 1997, so we're really lucky to have her on the line and be able to answer questions for us. There is a chat box on your screen as well, so when Lisa's finished her presentation, we'll open it up to any questions or anything like that. So please feel free to submit any questions during the presentation and we'll be able to answer them at the end. Lisa's been a sole practitioner with immigration law offices since 2004. And she's also worked with many Regal Maid services offices, both on initial applications and the renewal process. So, many people think once you get the visa, it's a end of story, but it's really a case of, it's an ongoing process that the business needs to be successful to grow and to also for the renewals. Lisa's based down in Orlando, Florida. As I say, Regal Maid service, when I was looking actually and doing the numbers, 75% of all Regal Maid service owners are on an E2 visa, either from the UK or Canada. So it's a great way for you to help your clients and for us to grow the business. So without further ado, I would like to introduce you to Lisa, who can explain how this visa works and how you can help your clients live the dream and move to the US.
Thank you, and thank you for inviting me to do this today. I love talking about what I love to do, and that's the practice of immigration law. I handle primarily business and family immigration. I don't really do the deportation and the court aspects of immigration. And I really enjoy the business immigration side and kind of have a little bit of a niche, I think, in the E2 area, the E2 investor visas. So what I'll do is really just kind of give an overview about the E2 visa, what it is, what are the criteria, and kind of everything you wanted to know about E2s, and hopefully it will be informative and helpful for everyone, and I'd love to address any specific questions that you have as well. So the E2 visa is called a treaty investor visa. The reason that it's called a treaty investor visa is we have to have a treaty in place between the US and one's country of citizenship in order for an individual to be eligible to apply for an E2 visa. And we don't have treaties with all countries. So some individuals are not able to apply for an E2 visa, even if they're going to make a substantial investment, and they'd be a perfect fit for it if they're not from a treaty country. Some of the countries where we do not have a treaty for the E2 includes Brazil, Venezuela, India. So individuals from those countries aren't able to obtain an E2 visa. However, I always ask my clients if they have dual nationality or perhaps if their spouse has dual nationality. There's a lot of folks, particularly in Latin America, who have dual citizenship. So it's not uncommon that someone might have a Brazilian passport but also have an Italian passport. Or they may be from Venezuela and they have a Venezuelan passport, but a spouse has a Spanish passport as well. And we do have treaties with Spain and Italy. So it's important to find out first if the individual has nationality from a treaty country. The list of the treaty countries is available on the State Department website, and that's travel.state.gov. It's called a reciprocity schedule. Reciprocity, RECIPROCITY. So if you just do a Google search under reciprocity schedule or E2 treaty countries reciprocity, it should take you to those links, or just go to the State Department website and type in E2 treaty list reciprocity. I'm also happy to provide information if sometimes a business broker will just shoot me an email and say, hey, I've got some folks in my office, they're from Brazil, do we have a treaty? And I never mind answering a question like that. I'd rather have someone be safe than sorry. So I'll give you my email address as well, and feel free to throw any questions about the treaties or any questions really about E2s after this presentation to me, and I don't really mind that at all. My email is lisa@lisavisa.com. So my website is lisavisa.com, and then the email is lisa@lisavisa.com. Or you can go to the website and it'll take you, there's a little inquiry form that'll take you to my email as well. So that's the first box that we have to tick for the E2 visa, just learning if there's a treaty or not for the individual who's interested in filing for an E2 visa. What's interesting too, when you look at that reciprocity schedule, it will show if there's a treaty available, and it will also show the maximum duration that someone can obtain an E2 visa. And that also varies country to country based on the treaties that are negotiated between governments. So for example, individuals from the UK can obtain an E2 visa for a maximum of 5 years, and that would be typical to apply for an E2 and get a 5-year visa. Thailand, for example, has a maximum of 6 months for an E2 visa, which is problematic if you've got an investor from Thailand who needs to travel frequently. If they apply for an E2 visa and they have only a 6-month visa and they enter the US and after 7 months they need to take a trip out of the country, they're going to have to apply for another visa. And that could be really cumbersome if they're having to apply for a visa every year or every 6 months or so. So sometimes those time frames can make or break the feasibility really for someone to have an E2 visa. I believe Egypt only has a 3-month visa, and we've had some individuals from Egypt that were interested in E2 and otherwise qualified, but when they found out they're only going to get a visa for no more than 3 months, that was kind of a deal killer. So that's something important to look at as well. So in addition to being a national of a treaty country, to obtain an E2 treaty investor visa, the investor has to show that they are actively in the process of investing or have already invested a substantial amount of money. What is a substantial amount of money or capital? It's really relative to the nature and value of the business that they're investing in. The business that they're investing in has to be a business, has to be a bona fide enterprise, commercial enterprise. It can't be like a vacant parcel of land that someone's going to invest in and then maybe sit on and flip after 5 years or so. So it's got to be a commercial enterprise that actually is engaged in kind of a trade in goods or services. And for the investor visa, an individual can invest a substantial amount of money by buying an existing business or starting a business from scratch. Can buy a franchise, which sometimes I kind of look at as a hybrid of a new and an existing business. If they're investing into a franchise, but it's a new location and they're not buying an existing franchise that has already been operating. So it's akin to a new business, but not completely new in the sense that, we've got a brand new idea and we're hopeful that it's going to work. With a new franchise location or opportunity, it's not necessarily a brand new business when you've got the strength of prior franchisees and the documentation or information about the franchise. So it's a little bit of a mix there. An individual can also invest into an existing business, not by buying it outright, but also through a share purchase. The investor has to own at least 50% of a company that they're investing in for each purposes. So if someone is interested in a share purchase, they have to have at least 50% of the shares. Most of the time, what I see, I would say the majority of the time, is someone buying an existing business or investing into a franchise. So in order to determine what is substantial, we really have to look at the nature and value of the business. If there's a business for sale and it's selling for, let's say, $150,000, or there's a franchise opportunity, as with Regal Maids, and I don't know what they go for, but let's just use $150,000 as the number that it would take to acquire the business. A substantial amount is really having to put in at least 75% or more of the value of the business. So if an investor says, I've got $150,000 cash, we want to buy a business for $150,000, that's substantial. They're putting in the full value or the full amount of the business. If they say, well, our budget's only 125,000, but we found a business that we like for 150,000, and the seller is willing to issue a promissory note where we're going to pay out the difference of 25,000 over maybe 2 or 3 year period, that's okay too. So they kind of look at what is the investor bringing to the table up front, and is that substantial relative to the total value to acquire the business, or in the case of a brand new business, to get the business up and running. When it's a brand new business where someone has an idea, let's say a restaurant, and they're not buying an existing business, and we pretty much have to itemize what's it going to take for this business to be operational. And they need to show that they have already spent a substantial portion of that kind of out the door figure for the business to open. I think most investors are a little bit nervous about actually spending the money on a brand new business. Let's say in the case of a restaurant, they'd have to sign a lease and start buying equipment and building out the space and really putting the money in before they can apply for the visa. And that makes, I think, some people nervous that what if they're in $100,000 or so to a new business, apply for the visa, and they hit some kind of a snag. Now they may not be getting the visa to come over, and they put all that money into the business. So I think people feel generally more comfortable buying an existing business or a franchise where they have an agreement, a purchase contract, and then the investment really is a transfer of the investment funds, where typically the investment funds would be held in an escrow account by the closing attorney. And usually in the purchase contract, there would be a contingency clause that the money's in escrow for the purchase of the business, but if there is any problem with the visa, the deal is contingent on the visa being issued, and if the visa was not issued, then the money goes back to the buyer or the investor. And so there's a little bit of a comfort level there for most investors. But the consulates are fine with that too, because they can see that the money is out of the investor's hands, it's out of their control, and contractually they're bound, if the visa is issued, to buy the business and move forward with the closing. So that works. That kind of scenario of funds in escrow works fine for showing investment and commitment of the funds. We need to also show for the E2 visa that the investor is going to direct and develop the business enterprise. That's usually, I think, one of the easier criteria to meet. An individual doesn't really have to have a particular background or have a specific background related to the business that they're now going to acquire. So, for example, if someone says, well, I'm a retired police officer, and now we're looking at buying a cleaning company or a restaurant, and I've never really done that kind of thing before, as long as they have something in their background, some skill set, maybe personnel management, customer service, they're good with accounts, etc., and they're likely to be able to develop and direct the business, that's fine. So we've never really had any issues there. The only time I had an issue that I can think of on develop and direct the business is when we had an investor that was quite a bit older, and there's really generally no issue with age discrimination. So if somebody's a young, 75 and wants to invest and is capable of doing it, that's okay. But we did have an older lady who was going to invest in a business, and it was really more of a means to get her to the US to be with her family through the E2 mechanism. And the son-in-law was kind of driving the E2 process and the business purchase, even though the funds were the mother's. And I think she just didn't really have a clear picture of what it is she was going to be doing in the US. And while it was a good case on paper, she really wasn't able to articulate to the embassy that she was indeed going to be running the business, and in reality it probably was going to be the son that was going to run the business for her. So that's the only time that I've seen a problem with kind of develop and direct, where someone was deemed not really capable or able to develop and direct the business. Another criteria that we need to show for the E2 is that the business enterprise is not marginal, or that it has the ability to be non-marginal within a 5-year period. So what that kind of means is if someone is buying a business today that maybe is in existence for the last 5 years or so, and it's showing enough profit and or income to the owner or the seller that would be sufficient to support the investor and his or her family, and ideally the business is creating some jobs for others, that would be a non-marginal business. It should be fine for purposes of an E2. A marginal business really is one that isn't able to produce enough income to support the investor and family, or is one that really isn't creating any jobs for others. The consulates don't like, to approve E2 cases for, just a one person operation. They like to see that there's some job creation. I remember years ago, the London embassy used to say, we don't want to approve E2 cases for one man and his lawnmower. And what they kind of meant by that was they didn't want folks, who might buy a lawn care, landscaping company, but it was just kind of a one-man show. The investor was going to be mowing the lawns and doing the books, and maybe the spouse would be helping out in the office, that kind of thing, but it wasn't creating any jobs for others. It's not what they want to see. As far as creating employment for others, there are no set rules that any employment being created must be U.S. citizens or full-time employment. I've heard sometimes people say, oh, I understand that you have to have 3 or 4 U.S. citizens on the payroll. No such criteria. They're looking at whether or not there's any employment being created by the business, and that could be subcontract personnel, so individuals on 1099s, and can be part-time or full-time. It could also be direct employees who would receive a W-2, and again, it could be part-time, full-time. It doesn't really matter, and it's really what's appropriate to the nature of the business. So often with a service-oriented business, maybe with a cleaning company, it may be that all staff are subcontractors and there aren't any direct employees. That's okay. If that's appropriate for the nature of the business, that's not a problem. So they'll look at a combination of W-2s and or 1099s. As far as kind of looking at the figures too, as far as, well, what's enough to support a family to be kind of out of the non-marginal zone? Usually the embassy and myself, I would look at, if it's an existing business, I would look at the tax return, the last tax return, and see, well, what is the salary or owner's compensation or officer's compensation? What did the owner or owners draw as a salary from the business? And that combined with what is the net income or the net profit. I kind of take those two figures. So if a seller is selling a business, they said, well, I've paid myself $24,000 last year, and we made a profit of $30,000, and I'm the sole owner, then that's a business that netted $54,000 really to that owner. So if you have an investor buying that business and it's a husband, a wife, and 2 children, they're not setting the world on fire maybe with $54,000, but it's out of the marginal zone because a family of 4 can reasonably live off of $54,000. So that's kind of the way that I think most of the embassies will look at marginality and whether business is not marginal. Sometimes an investor will find a business that they're interested in buying and it's marginal today. Maybe it's being run into the ground, or it's not being run well, or the owners are retiring or have lost interest. Whatever the reason might be, it may be a business that has potential but isn't really doing well at the moment. That still can be an approvable E2 case if the investor can show that they have a plan to turn the business around, that while it may be marginal today, they have a plan to maybe invest additional monies into the business, or do more aggressive marketing, or maybe remodel if it's a physical location. If they can show that they've got fresh ideas and new ideas, and they're going to turn the business around and take it to a point where it's not marginal, that it can still be approved. In an instance like that, it's important to have a business plan that would include the plan for turning the business around, as well as typically 5 years of projections, as the regulations require that the business is not marginal or has the ability to become non-marginal within a 5-year time frame. So in that, in a scenario like that, we would need to have 5 years worth of projections, financial projections. The main issue for renewals of E2 visas is usually that the business has become marginal. So someone might have invested in a business that was doing well, made a substantial investment, they're directing and developing it, meet all the criteria for an E2. And then if the business does poorly, and it's time now to renew the visa, and they're not really making money off of the business, maybe they're able to survive because they have income from another source, or the spouse has a good job, or they've got property rental income, the embassies really don't take those other sources of income into account when it's time to renew a visa. They're going to look at the E2 enterprise and determine whether or not this business is marginal or not. So sometimes that happens, and it can be difficult for folks to get a renewal if the business has gone kind of in a downward fashion, and they really are not able the investor's not able to support himself and family off of the business. Nobody ever intends, I think, or wants to have a marginal business, but sometimes it happens. Sometimes people buy a business and maybe it was misrepresented, or it could be a turn in the nature of the business. I remember years ago, I had a client that started a new business, and it was a travel agency, and got the visa, came in, but about a year into it, he kind of saw the writing on the wall and realized that a travel agency probably wasn't going to be a great business going forward, particularly with the ability to do bookings now, on the internet for most folks. So in that scenario, what they did was they sold off whatever they could get from that travel agency, and they ended up reinvesting into a childcare center. And they salvaged their E2 because the E2 company, and I always suggest that a client, that the E2 investor kind of set up a company that doesn't have maybe a corporate name that's so specific. So if someone sets up ABC Travel Agency, Inc., and then they switch gears later or they sell that, they're kind of stuck with that corporate name unless they do a name change amendment. So I'll often say, maybe set up your company, Smith Enterprises USA, and then doing business as, let's say, Orlando Travel Agency, because that allows some wiggle room then to diversify, to expand, or sometimes to change direction completely. If the visa then is under, the broader umbrella company of, let's say, Smith Enterprises, and they buy, as in this case, a travel agency, and then sell it and then reinvest, then they just really need a fictitious name registration for the new business. Smith Enterprises is the E2 qualifying company, and even though they change direction, the embassies are okay with that. When it's time to renew, you've got to show the paper trail and show that we came in with this plan and this business we invested in, we sold it, we reinvested, and now we're working with a new business and need to have all the documents, typically for a renewal in that case, that would be provided normally for an initial filing. But that's not unusual for that to happen. Sometimes too, an investor may say, well, we're buying a cleaning company, we're buying a Regal Maid franchise, and it's under the umbrella of our E2 entity, but we'd like to diversify and maybe do some pool cleaning on the side for some of our clients. And that's fine too, to expand and to diversify under the umbrella of the E2. What I suggest though is that the investors don't set up a separate company, because the E2, they're tied in with the one entity. So better just to set up a separate business division and maybe register a doing business as, or a fictitious name for the new kind of branch of operations. Let's see, I'm just, I think as far as the criteria of the E2, we've kind of hit on most of those. The last kind of bullet point is that the investor has to show an intent to depart if the E2 status ends or terminates. So with most E2 applications, it's really just a matter of a simple statement from the investor saying, if the E2 status were to terminate, I would return to my home country. I intend to depart. So the idea is that if the business were to be sold, or if it failed, or the E2 status ended for whatever reason, someone's not going to stay on in the US or linger or overstay, that they'd go back to their home country. With the E2 applications, an E2 visa, and in fact any visa, can only be issued by a US embassy or the consulates out of the United States. And sometimes people think that, oh, can I apply for my visa with immigration, or can I extend my visa with immigration? The only way to get a visa, which is really a page that goes into the passport, is through a US embassy or consulate overseas. The visa is the document that goes into the passport, and it's really a travel document. I always say the visa is your travel document. If someone is issued, let's say they apply for an E2 visa at the London embassy, and they're issued a visa for 5 years, then over that 5-year period that the visa is valid, they're able to come to the US and come in and out and be admitted each time they enter as an E2. The visa itself doesn't control their lawful stay. It just allows them to be able to come to the US and at a port of entry, typically at the airport, or it could be a land border or a sea border, to present their passport with a valid visa in it. And then the Customs and Border Protection folks at the airport are able to admit that individual then in the status that's reflected on the visa. So the E2 investor would get the visa from the embassy or consulate, come to the US, and then be admitted by Customs and Border Protection as an E2 visa holder. The E2s are granted a 2-year admission period. So even if someone has a 5-year visa, they're not admitted for a 5-year duration. If they have a 6-month E2 visa, they're admitted for 2 years. If they have a 5-year visa, they're admitted for 2 years. If they have a 1-year visa, they're admitted for 2 years. So the admission date for E2s is a 2-year time frame. The only time that it would be less than 2 years is if someone's passport was expiring before that 2-year period. Then the admission of the E2 into the US would only be until the date of the passport expiration. When an individual comes into the US and then they're admitted as an E2 and given that 2-year time frame, sometimes immigration will stamp the passport with that admission date and the end date. And then they also issue a form called an I-94. It's an entry departure record. In the past, it used to be a little white card that would be stapled into the passport, and that was the I-94 entry departure record that controlled one's lawful stay. Now they've gone to an electronic system where the Customs and Border Protection officers enter the data in the computer, and the I-94 entry departure record is done electronically, and it's accessible online. If any individual just does an internet search and types in I-94 online retrieval, it'll take you to the website to pull up the I-94 admission record and show the date of entry, passport number, and the date of expiration. I think it's always a good idea for folks on an E2 to check that I-94, because sometimes Customs and Border Protection makes a mistake and they'll admit someone for the wrong period of time. It's a little confusing when you might have a 5-year visa but a 2-year admission, and sometimes those officers at the airport get a little bit confused by their own rules. And so it's important that that one always checks the I-94 to make sure that it's accurate, and if it's not, it can be corrected. Another important thing about that admission record is that's what controls an individual's lawful stay in the US. So let's say someone has just gotten a visa for 5 years. They've come in, maybe husband, wife, 2 children. They all have E2 visas. They enter and they're admitted for 2 years. They're working hard in the business, and now it's 1 year and 11 months into being in the US, and they haven't gone anywhere. They've got a couple of choices then. When that I-94 record is expiring, before it expires, they either have to leave the US and then come back in and get a fresh 2 years, so effectively extend their stay by virtue of taking a trip out and coming back in. If they really did not want to travel or couldn't travel for some reason, then the I-94 entry record can be extended for 2 years by filing with immigration here with USCIS, it's US Citizenship and Immigration Services, by filing an extension petition and asking them to grant a further 2 years. When that extension petition is filed with immigration, though, the individual has to file tax returns, payroll records, business licenses, invoices, bank statements, proof that the business is still active and operating, that it's that they had they're still directing and developing it, and it's fairly cumbersome to get that extension. So most of the time, as long as the visa is still valid, clients generally prefer just to take a trip out and come back in and get the 2 years that way. I usually tell people it's a lot more fun to take a flight down to the Bahamas and spend a night or two and come back in with your fresh 2 years than hire me to put all that documentation together and file an extension with immigration and pay the filing fees and legal fees. But it is an option. As far as renewing the visa, then, as I mentioned, when it's time to renew the visa, it could only be renewed outside the US at a US consulate or embassy. So someone might have a 5-year visa, they've come in for 2 years, they've taken a trip out at some point, they come back in, they get another 2 years, and they kind of keep that going. When that 5-year visa is due to expire, It's okay if the visa expires or lapses if they're in the US in lawful status. So you can turn a 5-year visa effectively into a 7-year stay if you take a trip out of the country toward the tail end of the visa validity, as long as there's time remaining on the visa, even if there's only a month or two left on there and the passport's still valid for a further 2 years, they're still admitted for a fresh 2 years. So somebody might take a trip out of the country a few months before a 5-year visa expires. They come back in, they get a fresh 2-year admission, and now they're here legally and they're still continuing to work in their E2 business, and they're here perfectly lawfully, and the visa might expire. It's okay if the visa expires and maybe they let it expire for a few months or even a year, and then they might reapply for a new visa at the embassy or consulate. Sometimes it just is a matter of, whether or not people can have the time, to be able to leave the country and get the new visa and come back in. The only downside to letting the visa expire in that kind of scenario is that if there is a need to travel on an urgent basis, if there's elderly parents overseas or family members, and someone says, well, I let the visa lapse because we're here lawfully in the US and we weren't in a rush to go anywhere right now, but now there's an emergency. If they leave the US, they're not going to be able to come back in unless they get a new E2, and then they have to file all the paperwork and wait for the processing and then come back in. So that's not a great idea to let the visa expire, particularly for people that may have a need to leave the US, and it's often related to family being overseas. Let's see, with the E2, one of the upsides of the E2 is that it can effectively be renewed indefinitely as long as an individual is still, directing and developing a business, and the business is still up and running and it's not marginal. So somebody could be here for 15, 20 years under an E2. In a way, that's, for many folks on an E2, that can feel like the downside too, is that they've got to keep renewing the visa, and there's no direct path from an E2 to a green card. An E2 is the non-immigrant visa, so it's not permanent residence in the US. But many folks on an E2 will end up getting a green card, perhaps through a family relationship where maybe there is a single investor and they fall in love and marry a citizen, or they have an older child who may have acquired a green card through marriage. It could be that someone on an E2, that their spouse has a work authorization card and the spouse is working for a company that sponsors them for permanent residence, and then the whole family gets a green card. There's various routes for permanent residence that may be available to some. We have a diversity visa lottery as well, which is not something that individuals from all countries can apply for. It's really for countries where we have lower amounts of immigration. There's sort of a random lottery program where they can put their name in a hat, and if they're selected, they can essentially win a green card. And I've had folks on an E2 who've won the visa lottery and gotten a green card that way. The UK is not one of the countries that permits the visa lottery. So the folks that I've had that have won have been from, I think, Belgium and Switzerland and other countries where we don't have high numbers of immigration. I don't know if we have that much time today to talk about different green card routes, and it's a little bit of a departure from the E2, so I'm not going to go into much detail on that. But if there's questions on that, I'm happy to answer that. With regard to the family members for the E2, oftentimes a typical scenario for me might be a husband and wife, and say 2 children, and husband and wife intend to buy a business or invest in the business. The funds might be joint funds, and the plan may be that they're going to run the business together, and they maybe want to own the business 50-50. I'll often suggest, go ahead and set up a company, let's say it's ABC Enterprises, and go ahead and own it 50-50, but one person may choose then to be the principal E2 investor and allow the other party to come in simply on an E2 spouse visa. The advantage to one or the other spouse coming in on the spousal visa is that an E2 spouse can get a work card in the US. And with the work card, they can work in the E2 business, but it also gives them the flexibility to be able to work elsewhere as well. So if they wanted to get a job on the side, or if it's a newer business and they're not sure that they're going to be able to grow it, quick enough or to make ends meet maybe in the early days, they might like the idea that one spouse can get a full-time job or a part-time job to earn supplemental income. Sometimes someone has a particular interest. It might be they're a yoga instructor and they intend to work in the E2 business with their spouse, but they'd love to get, a job on the side. teaching yoga at the YMCA, and they would need a work card to do that. Or here in Orlando, it might be, someone wants to work on the weekends at Disney to get free passes or some benefits, things like that. So oftentimes I find if it's a husband and wife scenario, one or the other will choose to be the principal investor and the other will come in as the spouse. The only downside to that is if the marital relationship ends, let's say that, it's all joint funds and the business is owned 50-50, and one party comes in as the spouse and the other as the investor. If there's a divorce, the E2 spouse is no longer a spouse and loses their visa and loses their status. So that would be the only downside in a scenario where someone has come in as the spouse. Or God forbid, if the principal investor were to pass on, then the E2 spouse is no longer entitled to the spousal visa. If the funds are joint funds from the get-go and the business is kind of owned 50-50 from the get-go, and something like that happened where the principal passed on, then the E2 spouse could regroup and reapply and probably get an E2 investor visa in his or her own right. Sometimes people will structure the business and say, well, my husband's going to be the E2 spouse, he owns the business 100%. Or my husband will be the E2 investor owning the business 100%. I'm coming in strictly as an E2 spouse with a work card. And then someone might call me after a few years and say, ooh, guess what? We want to switch. My husband got a great job offer, but he's the principal E2 investor, not the spouse. Can we make him the spouse now and have him get a work card so we can go work elsewhere? And can we kind of flip-flop? If the business was set up with the initial investment and ownership all being in the husband's name, then you can't really later on change that so that you now claim that the wife had equally invested those funds and sort of reverse the E2. So I usually suggest doing it 50-50 from the get-go. The spouse, as I mentioned, then can accompany the principal investor and get a work card. Children can also come in with the principal investor as long as they're under the age of 21, but they don't get work authorization. And that's not a big deal when they're 6 or 8 or 10. Sometimes it becomes an issue when they're 17, 18, 19, and they're here as E2 children and they want to get a job at the mall or at McDonald's. They're not authorized to do that. So the E2 children don't get a work card. They can legally live here though and go to school. When the children turn 21, they're no longer a child for E2 visa purposes. And so if the family's still on an E2 and they have a child that's turning 21, if the child is in college or university here in the US, it can be possible to switch them over to a student visa. The tuition usually goes up because they're now paying international student visa or student fees, and they have to get the appropriate F1 visa. Sometimes we have children that are turning 21 that aren't college or university bound and no longer qualify as E2 children. And we may be able to get an E2 investor visa for them in their own right. Most 21-year-olds don't have a lot of money to invest, but sometimes it might be that they have been gifted funds by a grandparent or inherited funds, or it could be that the parents running their own E2 company were able to put aside money to be able to gift to a child so that they can now have their own E2 visa. Those are a few of the options for E2 children. I'm mindful of the time, thinking that we may only have, close to an hour, and I think we're about 45 minutes in. So I don't know if this is a good time or not for questions. Kind of feel like I've covered some of the main points that I wanted to on the E2, and I want to make sure that what I'm talking about is useful and relevant, and that any questions that you might have are answered.
Thanks, Lisa. I think it's you've been very, very informative, and even for myself, who's on an E2 and been here 12 years and gone through the process, I've still learned so much from listening to you.
Oh, I'm glad.
I think one of the things that I've learned, and one thing's when we talk about Regal Maid service and the franchises, and the fact that 75% of our owners are actually on an E2 process, there's a lot of hand holding that goes on, because it's not just as simple as packing a suitcase and moving here. You know, it's applying for your driving license, it's applying for your social security number, it's all the things that US citizens take for granted, but actually coming from a different country, it's a minefield. So personally for me, that was a huge thing. And knowing that there was someone within the company I was investing into that can help me with that was a huge thing as well.
I think the embassies too will, more favorably look at an E2 application where they see that there's going to be some support for someone who's coming to the US that may be running a business that they really have no background in, whether that's support from a franchisor or sometimes, the seller or owner that's going to stay on for a period of a month or two, that sort of thing.
Exactly.
That's always going to make the case, I think, that much stronger. Because at the end of the day, the embassies want to see that people are going to succeed as well.
Exactly. I think if anybody has any questions out there, if you just want to type them in, and then we can put them to Lisa and make the use of the time that we've got her.
And I guess too, a question that came to my mind that people often ask is, well, how long does the process take to get an E2? It varies from consulate to consulate. I do a lot of filings with the London Embassy. At the moment, the London Embassy is at about 45 calendar days, I would say, maybe getting a little closer to 60. Just given the holiday season. So that's pretty typical, I'd say, of a month and a half to maximum sort of 2 months. Other consulates are a little bit quicker. Toronto is actually really fast. They're, from the time that we submit documents, it really only takes them about, 2 weeks to review the documentation, and then we're able to schedule an interview. So they're pretty streamlined there. But it does vary a bit consulate to consulate, and it does vary, over time. Years ago, and quite a few years ago, London would take about 6 months on every E2. And that's no longer the case. And hopefully we won't ever get back to those days. I think much of the application process now is done electronically, and tighter filings, less documentation, a lot of paperwork that we scan and email now as opposed to sending over in a big binder. And that has moved things along. I think the government's trying to be a little bit more efficient with the whole process, and that's good for everyone.
Global warming does exist. One of the comment from Michael, who said this has been very helpful, which it really has. We have been recording the webinar, so it will be going live on our website, and we also have Kimberly Bonner on the phone, who is franchise development for Regal Maid service, and she'll be reaching out to everybody who registered for the webinar with any additional details, and we'll also include all of Lisa's contact information there as well.
Great.
A question from Tavi is, can an E2 investor apply for the EB5 after a few years with the profit from the E2 visa enterprise? Okay,
so that's a good question. So the EB5, there's really two types of EB5. EB5 stands for employment-based fifth preference category in the immigrant visa scheme, and an immigrant visa being a green card essentially, or US permanent residence. There's a variety of employment-based categories: extraordinary ability, multinational executives, managers, etc. And the immigrant investor is the EB5, the fifth preference category. When the program first came out, the EB5 program, it was designed to grant green cards to investors who were investing $1 million or more into a new US business, where they would also create 10 full-time jobs for US workers. And those jobs have to be direct employment, full-time, W-2, no subcontractors. If the investment is in a rural area or an area of high unemployment, then the figure is reduced to 500,000, but the investor still has to create 10 full-time jobs for US workers. So when that program first came out, and it was in the late 90s, it was underutilized. Just not that many investors had $1 million or more to invest and needed to hire 10 full-time workers. Some folks say, well, I'm going to put $1 million into a manufacturing plant, but I'm never going to need more than 8 people, or I'm going to hire 50 people, but they're all going to be subcontractors. Or it might be, we're starting a business and we hope to get to 10, 15 employees, but we can do this for 200,000. We're never going to get to $1 million. So the direct EB5, where someone's directly investing into the business, is pretty difficult. And most folks on the E2 don't go from the E2 to the EB5 very easily. A lot of the E2s that we see are smaller investment dollars, and the employment creation can also be an issue. It is possible in one's own business, if they are continually investing into the business and can show that they've invested $1 million and now have 10 full-time workers, to be able to possibly convert that into an EB5. But we have to be careful with profit or retained earnings from the business. If they're putting money back in, they've got retained earnings from the business, we can't really use that as investment. So it's not so easy to do those direct EB5s. It's almost got to be, like taking cash, $1 million, and putting it into the business. We did one for a couple years ago for a fellow who put over $1 million into a restaurant, a large-scale restaurant, and was creating more than 10 jobs for U.S. workers. But I don't have a lot of E2 folks that really have met the criteria. Some folks on the E2 have done really well and have been able to save money, or through the profit from their business, go the EB5 indirect investment route. And that is where, and that really now is about, I'd say 95% of all EB5s are now indirect investment into what are called regional center projects. Those are investment projects around the country that have been designated by immigration as a what they call regional center. The first one, I think, started in Seattle. It was an area of urban blight, an area of high unemployment, and there was a plan to redevelop the area into offices and condos, restaurants, etc. But the project needed many millions of dollars to come to fruition, and it was going to create lots of jobs. So they said, okay, we're going to designate this project as a regional center because it's an area of high unemployment. It qualifies for the $500,000 investment. And what we'll do is we'll allow multiple investors, maybe 20, 30 foreign investors, to each put in $500,000 into the project, and we'll attribute 10 jobs to each one of those investors as the jobs are being created. So that is kind of how the indirect EB5 works. And I have had folks on an E2 that maybe didn't qualify through their own E2 company, but were able to take $500,000, invest in one of those regional center projects, and get a green card for themselves and their family that way. I kind of look at the EB5 indirect investment as buying a green card for $500,000. You have to be very careful what project you invest in. Some of the projects have failed, and people lose not only their money but lose the green card. Some of the projects haven't really ever, come to pass, and some projects have had fraud involved with the various projects. So you do have to vet those really carefully. If that's something that someone is seriously looking at, I would definitely suggest that they work with an attorney that really specializes in the EB5 regional center area. And there's a couple of attorneys that I refer to for that work.
Thank you, Lisa. Another
Sure.
question from Michael. If we have a potential client that could utilize your services, what's the typical charges and timeline? I think from a timeline perspective, that once everything's together, it's a case on depending on the embassy that it's submitted to. But
Right.
in terms of charges, and also a question, is there a type of franchise that's more like...
Oh, I lost you there at the end.
Oh, sorry.
Okay.
Is there a specific type of franchise that is looked on more favorably by the government than another?
Okay, so I guess on the timing and the costs, timing, as you mentioned, can fluctuate a little bit from consulate to consulate, but generally no consulate is taking really more than 2 months at a time, and hopefully a little bit less. I always say the most difficult thing for the investor is finding the right business. Once they've kind of found that business, then things fall into place pretty quickly, and we can turn the cases around, fairly fast. As far preparing the application, maybe you need a week or two to kind of gather all the documents and assemble the case and prepare the qualifying letter to the embassy and all the exhibits. And the embassies are very specific about how each one wants things presented, and you've really got to follow their rules. If you exceed the size limit of a package, it'll be rejected. If you don't, file it electronically and you try to send it by mail and they don't accept those submissions, you could just lose time when you don't know what you're doing or not really paying attention to what the embassies require. Once the case has been reviewed, then an interview is typically made. Sometimes the appointments or the appointments are available within the week. Sometimes, like right now, because of the holidays, it could be 2, 3, 4 weeks out before an interview is available. And again, that depends a little bit on the embassy workload. Cost-wise, for our office, typically to register a company as an E2 qualifying entity with the embassy and obtain the investor visa for the principal investor, the legal fees are $6,000. And then we charge $500 per family member that requires either a spouse or a dependent child visa. There's also a visa application fee of $205 for the machine readable visa that's payable directly to the embassy. And then depending upon one's country of nationality, in some cases when the visa is issued, the embassy will collect an issuance fee. That's $105 for British individuals. Some countries don't have an issuance fee, but again, it does vary based on one's nationality. Typically what we do with new clients too is I try to schedule a 1-hour consultation, either by phone, Skype, or in the office, to go over all the ins and outs of the visa and the eligibilities, issues related to family members, long-term goals, green cards, all of that. And we charge $250 for the consultation. And if we're going to move forward with an E2 case or any other case for that matter, then the $250 is credited toward the total legal fees. And the one nice thing about immigration law is it's federal law. So unlike state law where you can only practice in a particular state, I've got clients throughout the US and really throughout the world. And we can file applications for individuals, whether they're in Florida or if they're in New York or Texas or whatnot, or if they've not even been to the US yet and they're overseas.
And the other question, Lisa, was, is there any particular type of franchise that's looked upon?
I wouldn't necessarily say that there's anything at the moment that I have felt that there's any franchises that are frowned upon. I think there was a period of time, maybe 10 years ago or so, when the London embassy was maybe getting a little tired of property management companies, but not franchises per se. I think franchises generally are looked on pretty favorably because they have the strength of the franchisor and the support of the franchisor. So I think sometimes having a franchise, for example, cleaning company, would actually maybe be an easier E2 than sort of a one-off mom and pop cleaning company.
Sure. It's funny when you talk about it, I can relate to all these things. We had 7 months to wait, and then, but 12 years later, it's you still remember.
Yes, I'm sure.
A question from Diane. Please explain how a travel visa, so I'm assuming a B1, B2 visa, can be turned into an E2 visa.
Okay, so that's a good question. If someone comes to the US with some type of a visa, whether it's a B1, B2 visitor visa or a student visa, or maybe they were on a work visa for a company, and now they want to change over to an E2 investor status, if they're in the US and they entered legally and they're maintaining that status pursuant to a visa admission, this doesn't apply to individuals who come in under the ESTA or the visa waiver program, where they can come to visit for 90 days and they don't need a visa. So only if they've entered with the visa and the passport. They have the option of filing with immigration here in the US to change their status. Let's say it was a student visa and they were studying English or something and now they found a business to buy. We can file with immigration here, present the E2 petition or filing with immigration and ask immigration to approve the E2 petition and grant a change of status over from the student visa to the E2. With an approval of that, they'll get an approval notice that essentially gives them a new I-94. It updates that admission record so that it wouldn't show that someone had entered as a student and maintains that status. It would have the approval notice and then show that they're now an E2 in E2 status, good for 2 years. The downside with doing a change of status and getting it approved by immigration is it's not a visa. So if you recall, the visas can only be issued by the U.S. Embassy or consulate outside the U.S., and the visa is really the travel document that allows one to be able to come in and out and be admitted each time they enter as an E2. When someone changes their status from a student or a visitor or any other over to the E2, that approval notice for 2 years is only good as long as they stay put in the U.S. So if someone does a status change and gets an approval for 2 years, and then after 6 months, their mother is ill and on her deathbed, and they leave the country, they've just left the approval behind. And the only way to return to the US is to then reapply with all the documents at the embassy in their home country, let the embassy review that, make an appointment, get the visa, and then be able to come back. So sometimes people that do the change of status like that will say, well, I'm landlocked here. They have that approval and it's good for 2 years, and then maybe 2 years later they extend it by filing again with immigration, and they do that every 2 years. So they're filing every 2 years with immigration, all the paperwork about the business. I don't think that's ideal, but sometimes people find themselves in that spot. And they usually say, well, we're landlocked here, or we're on a change of status, or we're on an extension of status. I always say that someone's not ever really landlocked because you can always leave, but it's the getting back in that's difficult, because if they leave and they don't have a visa and the passport, they've got to get the visa in order to return. Sometimes, strategically, I will say that there have been cases where if someone has the business that's kind of a borderline marginal one, some of the consulates, it's always, if someone, let's say, is running a cleaning company that's not a Regal Maids service and it's just, kind of limping along, I would sometimes feel nervous if they come to me and say, our visa is due to expire, or our stay is due to expire. We want to get a new visa at the embassy. And if it's a marginal business, sending them out of the country and going to the embassy where they might get a no and be stuck out of the US is a gamble. So sometimes in those scenarios, we'll say, I don't think you're going to get a visa if you leave the country, or if you do, you've got to be willing to take the risk that they're maybe likely to say no. We can try to extend your stay by filing with immigration and try to put together the best case we can, and fingers crossed, maybe get the approval. And so some folks will say, I'd rather take that chance and try to get it to go through immigration here than leave the country with the possibility of a no, and now I'm stuck out of the US with my home and dog and business here in the US, and they're elsewhere. So that would be a time when I might prefer to file an extension here. And sometimes it's a situation where, maybe a downturn in the business, but they've got, future promise that things are going to be looking brighter, and it may just be a bad time to file for the visa because it's dovetailing with a change in their circumstances. They might feel more comfortable trying to get a 2-year extension with immigration. And I have seen cases go through with immigration here on the extensions that probably wouldn't work at the embassy. They tend to be a little more lenient, and they will sometimes take into account other sources of income.
The question from Diane was, what is the ESTA 90-day visa?
Okay, so the visa waiver program, or the ESTA, which stands for, I don't remember exactly what it is. It's electronic something traveler authorization. Individuals from certain countries, and I have a list of those that I can share, where we don't have a high sort of percentage of visa overstays or fraud, or individuals coming as a visitor and never leaving. Most of the European countries are part of the visa waiver or ESTA program. So let's say someone is from the UK and they want to come visit the US, they can go online and register under the electronic something traveler authorization ESTA program. You have to answer certain questions. Have you been arrested, overstayed a visa before, things like that. And it doesn't take very long. It costs a nominal amount. I don't remember exactly what, but maybe $10 to $15 to pay for that. And they're kind of approved on the spot. With that ESTA approval, they can come to the US without having to get a visitor visa in order to visit the US, and they can stay for up to 90 days. But the restriction of that is that they can't extend the 90 days at all, nor can they change from the ESTA admission as a visitor for 90 days to an E2 or an F1 or an H1B or any other visa type. So The upside is they don't have to go to the embassy, apply for a visa. It's pretty cheap to get the ESTA. The downside is it's just a visit, no more than 90 days, no extensions, no change of status. And it is not possible for folks if they have a criminal record. They won't get approved for the ESTA, and then they would have to apply at the embassy of their home country for a visa.
Diane said thank you.
Oh, you're welcome.
Do we have any more questions for Lisa? You're just a font of all knowledge.
Oh, well, I hope so. I'm glad that it was useful. And as I said, any questions or follow-ups that anyone might have, feel free to email me. That's usually the best way to reach me.
That's
I'm happy to help.
Well, thank you ever so much. I think the questions have finished. On the final screen there, we've put Kim's contact details and also our email address and website if you have any questions or anything like that. And we'll also be reaching out to everybody with Lisa's details. So you can contact her directly, and if any clients need any help with any immigration, and by all means, I'm happy to help as well. I want to thank everybody that's joined the webinar this afternoon. I think it's been very, very informative, and thank you so much to Lisa for giving up her very valuable time and helping us with this.
Thank you, Joanne, for inviting me.
You're welcome. Thank you, everybody.
Okay. Happy holidays.
Thank you. Bye-bye.
Bye-bye.